Appreciate it. I don't know if you want to use this. I'll try to keep it close. I appreciate everybody coming out tonight and being able to be with you guys. It's funny, you see different, you go to different areas, and what that means to different people is, much different. Go to Salt Lake, and if you've got more than 2 kids, that's a large family. You go out here, and my 9 kids might be a small family, so it just kind of depends where you're at, but I appreciate the opportunity to come speak to you. I know, one of the challenges with speaking to a group like yourself is being able to find something and to talk about that is beneficial and something that's new. It's not just, this is the same old, these are the different delegated authority to Congress by the Constitution, things that you've probably heard lots of times or gone through in different Constitution courses, but to provide you with something that gives you value, that you say, okay, there are all the different things that I could have done tonight, I'm glad that I came here. And so that's one of the things that I really, really tried to do, especially with groups like the Constitution Party. And in honor of the Constitution Day, which was yesterday, I'm going to be talking about some important functions or important aspects of the Constitution that you don't hear in any class on the Constitution out there that is essential to understand if we are going to defend the Constitution and actually apply it. So right here, the title of the presentation is The Constitution for the United States. And that is, some people might think that that's a distinction without a difference, or they might not have ever heard it called that way before. It's usually referred to as the Constitution of the United States. But if we look at the preamble of the Constitution, it closes with the phrase, the Constitution for the United States of America. Now, but if you look at all the pocket constitutions out there, why do they all say of them? It's something that for the last 150 years or so, we've been kind of conditioned to switch from of to for. From for to of. And that's an important distinction. It's not just a distinction without a difference. It is the foundation of the Constitution. Without it, its interpretation is manipulated. We can change the entire meaning of the whole thing with just that small one-word change. Okay? So why does that change matter? So just kind of think of 2 different things. The Constitution of the United States means that it's a national government and that it created it's to govern a nation. Okay, that's what would it be, is if you're going to use the word of. But a Constitution for the United States means that the states created it to govern its creation. So what came first, the states or the federal government? States. Obviously the states, right? So it created something and to govern its creation. Now, here's something that you might start, I hope I don't get eggs thrown at me or picked up and thrown out of here today, but I'm going to ask a question today. Okay, what is America? This is hopefully pretty simple. Are we a democracy? No, right? No, we're not a democracy. How about a republic? A republic? No, I'm going to say no, actually. We're not a republic. Okay? That might shock you. And, I hope I'm getting a chance to explain myself. Okay? Okay, we're not a republic. What is America, though? Okay, go to the Constitution. Article 4, Section 4 of the Constitution is going to be where you're going to say, but Ben, it says, the United States shall guarantee to every state in this union a republican form of government, right? Nowhere in the Constitution does it say a democracy, but I'm going to say to you that nowhere in the Constitution does it say that the United States is a republic. The only time we see it mentioned is when it guarantees to every state in the union a republican form of government. This is a distinction we're going to get into. The states are sovereign. The general government is subject to the states and is not sovereign, and therefore it is not a republic. A republic is something that is sovereign, and the general government is not sovereign, but the states that created it are, because the general government is subject to its creator. So we'll continue on, right? What we are is a confederation of sovereign republics under the Constitution. And that's an important distinction that we're going to get into as we continue tonight. So before the Constitution, though, leading up to the Constitution, we have the first Continental Congress. It was held on September 5th, 1774. That's where all the different, right, Continental Congress. I put that in bold and italicized because the word Congress is important for us to understand, and I'm going to go back to that a little bit later. Representatives from 13 separate colonies came together to meet and to discuss what they would like to do, okay? Now, at this meeting, Benjamin Franklin wrote a letter to a gentleman that gave him, his name is Frederick Dumas, who sent everybody at the Continental Congress from all 13 colonies a book called Emmerich Duval's Law of Nations. He says that your book, your gift of Law of Nations, has been continually in the hands of the members of our Congress now sitting, okay? This was a gift to every single member of the Continental Congress. Now why? If you're all representatives from the same nation, you don't need a book on how to interact with other nations. But they had that book on how to interact with other nations. That's what that book was about, and that's what they were studying as they were meeting in the Continental Congress. Now, the states, of course, are superior. Now, today we're told that the states are just subdivisions of the federal government. But how can a creator be subject to what it created? That is putting natural law on its head, okay? In the Declaration of Independence, it teaches this principle. It says that these united colonies are and of right ought to be free and independent states. That they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved. Now, today we think of states as being subdivisions of a bigger entity, except for when we hear maybe the state of Israel. That's the only time you think of an independent nation being called a state in today's vernacular. But they're referring to independent nations as states, the nation state. So Great Britain was a state. It wasn't like a state in Europe, right, in the subdivision, political subdivision aspect, but it was an independent nation state. And they themselves are now independent nation states. And that as free and independent states, and I think, to be able to help us to get over the brainwashing, maybe we could transpose state into nation. As free and independent nations, they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent nations may of right do. Okay? To explain this a little bit further, right? On September 3rd, 1783, King George signs a peace treaty, not with one nation, but with 13 independent sovereign nations. It wasn't one peace treaty. So why does four actually matter? So getting back to the Constitution, Article 1, Section 1, you probably all have gone through classes and know what this talks about with the powers of Congress. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Okay? So what was the deliberative legislative body of the nation that they had just declared independence from called? What's England's monarchy? No, what's their legislative body called? Parliament, right? Parliament. So why did they call it Congress and not Parliament? Right? Were they just saying, we don't like you, we don't want to be part of England anymore, we're going to use different words? No, New York, right? They have lots of things that, English names that were here that they continue to use. There's a reason why they used Congress and not Parliament. But first we have to know the definitions of the words as they were used at the time, in the 1770s. Okay, so Parliament, according to Samuel Johnson's dictionary, people like that Webster's 1829 dictionary is great, but my favorite one to understand the words of the Founding Fathers is the Samuel Johnson dictionary, because that's the dictionary that explains the words as they were used in that time frame. And a parliament in the dictionary says that what its definition is the assembly of the king and three estates of the realm, namely the Lords spiritual, the Lords temporal, and commons for the debating of matters touching the commonwealth, especially the making and correcting of laws, which assembly of court is of all others the highest and of greatest authority. Okay? So, in layman's term, a parliament is an assembly that is under the authority of the king. Okay? So, did they call it a parliament because, they call it Congress because we don't have a king, but other than that, it's the exact same thing? No. Congress has a very distinct definition. And we go to, again, the Samuel Johnson Dictionary from the 1770s. Congress, the definition of Congress, might shock you, an appointed meeting for settlement of affairs between different nations. Okay, that's the word they used, the definition of the word that they used in the Constitution. They are settling the affairs between different nations. And they gave them that authority. Now again, Edmund Burke talks about this isn't just some mental thought exercise and all theoretical. No, in actual everyday common vernacular, this is the way that they spoke. They understood this as the definition. So Edmund Burke, a lot of you know his famous quote of, "The only thing necessary for evil to triumph is for good men to do nothing." That Edmund Burke, right? So in a speech to the electors of Bristol in 1774, he says, "Parliament is not a congress of ambassadors from different and hostile interests, which interests each must maintain as an agent and advocate against other agents and advocates. But Parliament is a deliberative assembly of one nation, one interest, that of the whole, where not local purposes, not local prejudices ought to guide, but the general good resulting from the general reason of the whole." So a parliament is a deliberative body for one nation, whereas a congress is a body of representatives from different nations coming together representing their nation, their nation's interests, their nation's prejudices, and their nation's interests are what guide them, not one nation, but their nation. Okay, so yes, 4 matters, because we have 13 sovereign nations that have come together to form a confederation, giving the new government limited powers relating to the combined actions of the still sovereign nations, nation states. Okay, so yes, the Constitution is for the states, not of a new nation. So we are 50 independent states, nations. So the United States is not a nation. We've been brainwashed by a socialist to say that we are one nation. But we are a union of sovereign republics. Okay, so why does that matter though? Okay, and that gets into the fact that the Constitution is a contract or a compact, kind of that word can be used interchangeably between 2 parties, the states and the federal government that it started. The principal and the agent, right? The principal is the individual that is creating the contract, or that is the owner of something, and the agent is the person that's being hired to do the thing, okay? And so if we look at it as a contract, this is the law of agency. We break it down to an individual homeowner, or landowner at this point. He's a landowner, and he wants to build a home on his land. So he reaches out and he hires a contractor to build him a home, okay? So they come together and they say, "You build me a home, 4 bedrooms, 3 baths, XYZ footage, and I'll pay you X amount of dollars, and we're all good," right? Okay, so he starts to build the house, but he says, "Man, this guy Joe, he has a family. He's got 3 or 4 kids, and you know what they would really like? A pool. They would love a pool. So I'm going to help them out, and I'm going to build them a pool. But of course, I'm not going to pay for it in my pocket. I'm going to build Joe. I'm going to build Joe for the pool as well." And so what happened? The contractor violated the contract, which makes the contract null and void. Any judge is going to throw that and says, "No, you're not responsible for that, Joe. You don't have to pay for that pool. You didn't say that you wanted it. You didn't promise to pay for it. You don't have to pay for it. In fact, if you don't want that pool, the contractor is obligated to, make it whole again." And so what happens? You fire the contractor, right? You violate the contract, you either hold them to it or you get rid of them. That is what the Constitution was set up to be. We have a contract between the states that created it and the creation, that here are certain enumerated powers, and if you go beyond those, you are violating the contract. Okay? James Madison, in Federalist 45, just as I'm sure you all are aware, the Federalist Papers were the letters or articles written in local newspapers to sell the local people on the Constitution, to say this is what it's about, and to maybe debunk any falsehoods being stated by detractors of the Constitution, explain what it was all about. So in Federalist 45, James Madison says, the powers delegated by the proposed Constitution to the federal government are few and defined. Okay, they're very specific. Those which are to remain in the state or national governments are numerous and indefinite, because it's not discussed in the Constitution. The former will be exercised principally on external objects, such as war, peace, negotiation of foreign commerce, with which last the power of taxation will, for the most part, be connected. So explaining what are those few things delegated to the national government, which I'm sure you guys all have heard before. But as he continues on, he says, the powers reserved to the several states will extend to all objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people and the internal order, improvement, and prosperity of the state. So those things are things that are off limits to this new federal government that was created. And those are all reserved to the states themselves. And so, of course, people where power accumulates, people want to take more than what's given to them. And so the state of Virginia and Kentucky, they said, okay, there was a point where they felt that the contract that they had entered into was violated. And so they entered into resolutions nullifying those federal laws. And then in 1798, and then in 2 years later, in 1800, James Madison presents himself to the Virginia legislature, talking further about those nullification resolutions, where he talks about, he says, the next position is that the General Assembly views the powers of the federal government as limited by the plain sense and intention of the instrument constituting the compact, and as no farther valid than they are authorized by the grants therein enumerated. So he's saying that the Constitution, the powers given to the federal government, go just as far as the things that they are authorized to do, and that's it. If the powers granted be valid, it is solely because they are granted. So the powers they have, they're only valid if they were granted specifically. And if the granted powers are valid because granted, all other powers not granted must not be valid. So if the federal government is doing something that it was not given a power to do, it is not a valid power. You go back to the Declaration of Independence, and they referred to this, what the king was doing at that time, as pretend legislation. So what the federal government, anytime that the federal government does things that they are not specifically granted the power to do, they are engaged in pretend legislation. James Madison continues, the states then being the parties to the constitutional compact, and in their sovereign capacity, it follows of necessity that there can be no tribunal above their authority to decide in their last resort whether the compact made by them be violated, okay? This is a key thing, because you'll see all the time where governors, we would like them to stand up against radical activist judges going beyond their scope. And that's exactly what James Madison says, is that, no, you don't have to kowtow to the judges, because the courts have no authority to tell the states when the Constitution's been violated or not. That would be like a creator. It'd be like your teenage child telling you when you've violated the rules that you've given to them, right? They get to decide when they violated their own rules, or the rules that you've given to them. That does not make any sense. That does not work, and that, of course, puts tyranny into the hands of the created. It says, no, the states are the ultimate last arbiter of when the Constitution has been violated. They are the ones that get to decide, and then they get to decide what they're going to do. Are they going to just leave the contract, or are they going to try and enforce it? And consequently, that as the parties to it, they must themselves decide as the last resort such questions as may be of sufficient magnitude to require their interposition, meaning, are they going to stand in and stop this illegal action from happening? And so in the Articles of the Kentucky Resolution of 1798, so we have Virginia and we have Kentucky, 1798, nullifying federal acts of the government, acts of the federal government. He says that the several states composing the United States of America are not united on the principle of unlimited submission to their general government. They are saying, as a parent, I am not going to submit myself to my teenage child and whatever they say. Right? That's not what they're going to do. But that by a compact, under the style and title of a Constitution for the United States, he says it again right here, Constitution for the United States, and of amendments thereto, they constituted a general government for special purposes. So that general government was only given powers for special circumstances, not general unlimited power to do whatever they think is within the best interests of this nation, but for special purposes. Okay? So now this principle goes into the Constitution, right? The compact, the definition again, a formal agreement or contract between two or more parties. So when you call the Constitution a compact, you're calling it a contract. A contract has very specific delineated powers inside of it. Okay? Now we go to Article 7. The ratification of the Convention of nine states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. So even the Constitution itself says that this is an agreement between the states. And so there are 13 states at this time, independent nations, and they're saying that 9 states are enough to make the Constitution in effect. Okay? So if, let's say, 9 out of the 13 sign on and it's in effect, does that mean those other 4 nations are forced to be a part of it? No. Just those that voluntarily sign on to it are now subject to it. Everyone else gets to go about their business. So in Amendment 10 goes into this even more, says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Prohibited by it to the nations, reserved to the nations respectively or to the people. So again, just like James Madison said, the Constitution says if you are not given a power to do something, you don't have the power to do so. And if you do the thing that you don't have the power to do, you are engaged in pretend legislation. So now we go to James Madison in the ratifying convention. So we're trying to sell the Constitution to the legislature of Virginia. And it tells them clearly, according to the expositors of the law of nations, that a breach of any one article by any one party leaves all other parties at liberty to consider the whole convention to be dissolved, unless they choose rather to compel the delinquent party to repair the breach. So Virginia, as one of the parties, one of the principals, if they see that its creation is going beyond it, they can decide 2 choices. Are they going to dissolve it, or are they going to compel the delinquent party to repair the breach? Those are the 2 options for the principal parties, the states, to be able to decide what they're going to do. So America is not one nation, but again, a confederation of republics. So Patrick Henry in Virginia, he was what's referred to as an anti-federalist. He was worried about the Constitution being conglomerated into too much power. And he says, if consolidation proves to be as mischievous to this country as it has been to other countries, what will the poor inhabitants of this country do? This government will operate like an ambuscade or an ambush. It will destroy the state governments and swallow the liberties of the people without giving previous notice. Now, some would say Patrick Henry, maybe history has proven him to be a pretty smart guy. But James Madison, understanding, being the father of the Constitution, understanding what their intent was, explained, were it as the gentleman asserts, a consolidated government, the assent of a majority of the people would be sufficient for its establishment. And as a majority have adopted it already, the remaining states would be bound by the act of the majority, even if they unanimously reprobated it. But sir, no state is bound by it without its own consent. So he's saying that it's not one nation. We are not a nation. Otherwise, if we were, then just a majority of the people in these 13 colonies voting for it would be enough to make it binding on everybody. But he's saying, no, it is not that way, because we are 13 independent sovereign nations deciding to join on whether if we want to or not, of our own free will. So James Madison again, in the Virginia Resolutions of 1798, he says that this assembly doth explicitly and peremptorily declare that it views the powers of the federal government as resulting from the compact to which the states are parties. Okay? Again, these guys said it over and over again because so many people were afraid of it becoming this idea of they get to do whatever they want. But they're over and over again saying that no, that this government only is allowed to do the specific things that the Constitution gave them the authority to do, as limited by the plain sense and intention of the instrument constituting compact, as no further valid, that they are authorized by the grants enumerated in that compact. And in Federalist 39, selling the Constitution again, he says, the act of the people as forming so many independent states, not as forming one aggregate nation. So again, he's telling the people that no, you don't have to worry about this creating a new nation. You are still independent sovereign nations. We are not forming an aggregate nation. Each state, in ratifying the Constitution, is considered as a sovereign body, independent of all others, and only to be bound by its own voluntary act. In this relation, then, the new Constitution will, if established, be a federal and not a national constitution. Okay? This Constitution is a federal, not a national constitution. Now, in today's world, right, we think of federal and national being the same thing. Like, how can it be federal but not national? Those are interchangeable terms. We think of federal government, national government, interchange. That's because we've been lied to about what these words actually mean. And it's on purpose to be able to get us into a situation that Patrick Henry said we'd get into. But it could only happen if we were lied to about what these words mean. So what does federal mean? Okay? Federal, relating to a league or contract. So this is a contract, not a national government. That's what he means by federal, not national. We're not creating a new nation. We're creating a contract between 13 independent sovereign nations that will maintain and retain their sovereignty. And in 39, he says that very thing. He says, we're the people regarded in this transaction of forming one nation, the will of the majority of the people, of the whole people of the United States would bind the minority, in the same manner as the majority in each state must bind the minority. So this is one of the reasons why we see the importance of the Electoral College. We are not, because the Electoral College allows the states to maintain their independence in choosing who the president will be. If we accept a national popular vote, we are giving up our sovereignty. We are giving up our independence as a state, as a nation. And that's why one of the biggest dangers in eroding ourselves as the independence of our nation, the nation of Utah, for example, was the 17th Amendment, because now it got rid of that independence. And the will of the majority must be determined either by a comparison of the individual votes or by considering the will of the majority of the states as evidence of the will of the majority of the people of the United States. Neither of these rules have been adopted. Each state, in ratifying the Constitution, is considered as a sovereign body, independent of all others, and only to be bound by its own voluntary act. So even after we sign on to the Constitution, we are only bound by our voluntary acts. And this idea of independent sovereign republics, this confederation of independent sovereign republics, was something today would be very strange to your average school kid learning American history and American civics, but was something up till the mid-1800s was very commonly understood. There is this, we have a copy of this catechism on political catechism, and it was something for children to learn about what kind of government do we have with the Constitution. And so this idea of a separation between these independent sovereign nation states was well known. So a catechism, if you're not aware, Catholics use, there's Catholic catechisms. It was actually something that all schools used to be able to teach children in early America, where they would have a question that the child would memorize, and then they would have the answer that then you would then memorize. And so that's what a catechism is, and this is how they would learn. And so in this catechism, the question that the child would memorize was, question, what do we understand by the federal union? So now that we've learned what federal means, right? It's a contract, not a nation. Answer, it is an agreement between sovereign states to forbear exerting their sovereign power over certain objects and to exert jointly their sovereign power over other specified objects through the agency of a general government. Each state agrees to exert its full sovereign power jointly for all external purposes and separately for all internal purposes like police or state concerns. Question, where is this agreement found? It is in the bond of union or compact between the states called the Federal Constitution. Finally, well, it's not finally, but this is the last question I'm going to, part of the catechism I'm going to share. The question is, did the states on forming the Constitution divest themselves of any part of their sovereignty? Was any part of their independence given up when they signed on to this contract? Not a particle. The individuality and sovereign personality of the states was not at all impaired. The Constitution is their power of attorney and to do certain acts, and contains connected with their authority to act their letter of instruction as to the manner in which they shall act. They are the servants. The power which gives validity to their acts is their master, the states. The states are their master. Children knew this, where today hardly any adults know this. We are taught that we are all of the states are just political subdivisions like a county would be in a state, as opposed to what we are, the creator and the master. So when we defend the Constitution, this Constitution Day, some principles. We understand the Constitution is a contract between sovereign nations that maintained their sovereignty. Evil and designing men have worked for over 150 years to get us to forget this fact and to get us to support a national tyranny. States must defend their sovereignty to defend the Constitution. When a state defends itself against the encroachments of the federal government, they are defending the Constitution. They are not being subversive, they are not being rebellious, they are defending the Constitution. And we defend the Constitution by understanding it, not just accepting definitions that were given to us in government schools, right? The government schools are not going to train us to learn things that would undermine its authority. We have to look at what the founding fathers understood these words to mean. Defending the independence of each state, right? Just that one word, Congress. Understanding that Congress is a deliberative body of separate independent nations coming together to represent their independent interests. They are not to come together to represent the interest of one nation. Not referring to the United States as a nation is a way to defend the Constitution. To understand that we are a confederation of independent republics. And that our nation that we are in today, the nation of Utah, and its independence is what we need to support to defend the Constitution. And then to keep the federal government within its bounds and going on the offense, saying, you know what, federal government, you have violated the contract. Now, are we going to go to the extreme of just dissolving that contract, or are we going to defend the contract, defend the Constitution, and put them back in their place? Make them fill in the pool, right? And join with others like the Tree of Liberty Society that come together to be able to better understand these principles. In the Tree of Liberty Society, our goal is to build the understanding that has built free nations, to expose the conspiracy that seeks to destroy it, and to organize to stop that conspiracy. And so I encourage you to go to the Tree of Liberty Society to become a member, to support our efforts to be able to defend the Constitution against those that would seek to impart a federal tyranny or a national tyranny. And one of the tools that we have to be able to do that we have today is at our book table. Our book has been banned on Amazon, so you can tell it's got some information in there that they don't want you to know. But it exposes how the globalists infiltrate state and local governments, and then what you can do about it. It's not just a doom and gloom, it is telling you where we're at, but then saying that there are solutions for it. So on the website, the books are $20, but they're not there. What we're doing today is we want to get these out. We want to help people understand these principles, and so they're $10, or if you get 4, you buy 3, we'll give you the 4th one for free. That way we're getting it out there, we're having more people read these things and understand them. And so with that, maybe open it up to question and answer time. Any questions? Yeah.
Can you elaborate on the solutions in the book?
In the book it goes through, so what we've seen in the last 100 years or so is this idea of voting harder, suing the government, protesting, and those are things that all say that I have to depend on the government to give me my rights. But we recognize that our rights come from God. And so those things are designed to get us to spin our wheels and to not actually move forward. And so what we're doing is we're going back. But the Founding Fathers looked at ancient civilizations to say, what is the most stable form of government? What will stay and protect the people's liberty for the longest period of time? We've done the same thing of looking throughout history of how have enslaved people regained lost liberty, and going through and looking at those. And so those are all laid out, those things such as nullification, interposition, what James Madison says in Federalist 47 of being able to understand, first understanding. As we can see tonight, there are lots of things that we still don't understand. As many classes of the Constitution that we've gone through, there's key information that we don't get, so we need to build our understanding and then go on the offense to be able to say this far and no further. So that's kind of a bumper sticker version of what we're talking about. Yeah?
General comment is that I know that the focus here is on the sovereignty of the states.
Yeah.
The reality is you can look at any state constitution right within the first or second section is that all political power is in the people.
Mm-hmm.
It was the people that created the Constitution to begin with.
Correct.
And the state constitutions, the compacts before with the Articles of Confederation, as you know, and so forth. And so the people really do not understand fundamental law.
Mm-hmm.
That's the biggest problem that I've seen, and I'm involved with organizations that we've written thousands of notices and actually moved the Supreme Court to do their job. Under the radar screen, there's no credit, no one's looking for anything, right? And so it's through a series of consolidated notices, people acting from their sovereign capacity and not for the normal patriot nonsense kind of things, all right? This is just citing the law as it was originally done. And I can point to very specific things, even within Utah, where over time, they've completely obliterated the original constitution of the state of Utah. Mm-hmm. In fact, I would go so far as to say that the original constitutions in Utah was against the other constitutions, which we have the right to be able to acquiesce any other constitution in this country because we are one union, right? To give you an example, the original Constitution in Utah, where it says, all men shall have the right, In 2020, they changed that to all persons. All persons. And they took away the enactment clause and the style with a single title for a particular law, all of which is completely against 1,000 years of tradition. But they've done it, and I'm sure many other states have done it too, and they have a private committee that actually creates the revised statutes, and all of the codes are all bogus laws. That's a fact, and I'm sure you know that.
Yeah, and that gets into, I think, both questions. Is what we're doing is not just saying that I don't have my rights until the judge says so. I don't have my rights until the legislative body says so. When during the fake pandemic of 2020, and the governor said that you were not allowed to meet together in groups of 10 or more, we didn't say, okay, let's get the legislature to repeal that, and then we can meet together again. Let's sue the government. Let's get a robber, and let's get his buddy, another robber, to say, hey, robber, does your buddy, the other robber, did he violate my rights? No, that's not going to work. And so what we did was we said, okay, that's illegal. It's a pretend legislation. And so we went to the Capitol. It was a limit of 10. At the time, people were still afraid, so we had about a couple of dozen show up at the Capitol on the steps, and we got together and we had a picnic in defiance of the governor right there without waiting for his permission. And then when they did the shutdown, when they said businesses weren't allowed to be open, we were able to find a restaurant in Utah County that said, you know what, if you will help us out and will support us, we'll open up when everybody else is closed. And so within a 3-hour period, we had 300 people filling that restaurant. And so we're not saying that there's not a magic trick that says if you just mail in your birth certificate, then the government leaves you alone. What we're saying is that the founding fathers, they did not say, I'm going to write a sternly written letter to the king and hope they get my rights back. No, or I'm not going to sue the king and get my rights back. They were willing to put their life on the line, and they were saying, I'm going to take the consequence of this. And so could that restaurant have been punished by the state? Yes, they could have, but they were willing to do so because they had their fellow community members saying, I will back you up. And so there is a risk to doing these things, but there is a bigger risk not doing them, and that is increased tyranny. And so,
So I'm so glad to learn the definitions.
Mm-hmm.
Thank you very, very much. And what came into my mind the whole time was how our verbiage is being changed all the time. All the time. For instance, we have been told, and I have been told, that it's a privilege to drive my car. It's a privilege to drive. It's a privilege to drive. No, it is not. It is my constitutional right to drive. And if you tell me that it's a privilege, you are infringing on my liberty rights and my property rights. It's my liberty to get in my car and drive from point A to point B, and it's my property. And I look them right square in the face and say, it is not a privilege to drive. They are twisting and changing our verbiage. And thank you. And I had so much more, and then it just left me. But my dad was a World War II vet. His whole life was love of country, family, and then God. His life was country. He pulled us aside and taught us the Constitution, the principles, how to apply them, and how to recognize if the law is unconstitutional or not. He would walk around the house and something would come on TV and he'd go, the law. The law. They're trying to tell us we live the laws of this land, and that's a blatant lie. Because if it's not in harmony with the Constitution, it's null and void. The law of this land is the Constitution. And I actually became a member of the Church of Jesus Christ of Latter-day Saints based on that. Because when the missionaries came and knocked on my door, they handed me a card. And the first thing I did was look at it and then turn it around. Anybody who's a Latter-day Saint knows section Article 12? We believe in being subject to rulers, kings, and magistrates in honoring, sustaining, and obeying the law. I had great big tears rolling down my face. Turned it around and said, it's not plural. It doesn't say honoring, sustaining, obeying the laws. You will not find that. It's the law. And the missionaries opened up a book, and it said, the law of this land is the Constitution, and anything more or less than this becometh of evil. And in another section, right there on my porch, they went a couple pages, and it said, the constitutional law for this land, is the Constitution which I have established, quoting Jesus Christ. I said to them, come in.
Amen.
Yeah, I do.
So, I agree with the wordplay, the trickery, but she kind of fell for it twice by using drive, because when you drive a motor vehicle, you do have a privilege because it's considered commercial, but do you have the right to travel? Yeah, so
Yeah.
there's so much
There's so much
wordplay
more.
in all of it.
Yeah.
Or just a note that those licenses are, on the registration and licensing of the commercial traveling is only for interstate commerce. And they've tricked us all to believe that it applies to all travel, which it does not. I went to register my car in California, and the form starts out with the phrase, if you are required to register your vehicle. So I marched right back over to the lady and asked the lady, how do I know if this applies to me? She said, I don't know. You just have to do it. That's what it comes down to. It's the ignorance of the people. And that's what I think Ben has proven to us tonight, those of us who love the Constitution, and yet all of these little details here, none of us knew that. None of us knew it.
And all of us
It's
know
been
that their
intentional.
driver's license is unconstitutional. People were driving horse and buggy for how long? And then when the invention of the automobile came, how many hundreds of people were driving? Thousands of people were driving an automobile. And all of a sudden, oh, we can make some money. We can make some money. And do you know your driver's license only had your name on it with a number? That's all there was. The first driver's license that came out. That's what my grandfather said. His driver's license had his name, Harold Eugene Mattern, and he was something like, I don't know, 722. And that's all there was. Now they have to have your address and how high, your height and eyes, color, and all this stuff. And if you move, you only have 30 days to tell the government you moved. You're not allowed to free move, and you have to contact them. Baloney.
They used to have your social security number on it too.
Wow.
We had two in the back row, and then, yeah.
Yes, there are state-owned roads and federally owned roads in the state. You can drive your car without a license, but if you're on a state road, you have to have the state's permission because they maintain them. Likewise with federal roads like I-15.
Yes, hold on, Greg, after, yeah, yes.
I just, maybe this is opening up a bit of work and works, but the Pledge of Allegiance, what are your comments about that? Because we talk about,
Yeah.
we were using the vocabulary over and over, so, again, maybe that shouldn't have been said, but I just
No.
was curious.
Yeah, that's true.
So I have an article that goes into detail on the Tree of Liberty Society website, but I think you can tell by the words that I use tonight that it is not something that I am a fan of. I think it was a little bit of the history. It was written by a socialist, and it was designed to promote the idea of one nation, and that it was designed to make it not a contract where it is indivisible. Can you imagine a contract? Can you imagine a husband and wife, and the husband becomes abusive, and the wife wants to leave, and she were to say, I want to leave, and he's like, well, this is indivisible, and that the abuses that would maintain. And so just like James Madison said over and over again, that this is a contract that we've entered into of our own free will. That is the intention of the Founding Fathers. And so I think that the Pledge of Allegiance goes contrary to the intention of the Founding Fathers. Yeah, great.
So I was going to say, Ben, the states do not have the final say-so on what the law is. We the people, in our capacity as jurors, decide what the law is.
One's convicted, yeah.
And so this is called jury nullification. So
Yep.
the juries have the final say-so. on what
If somebody's convicted, but like a state legislature is the final line to, are they going to implement, are they going to enforce an unconstitutional federal law? And then, of course, if they are going to do that illegally, then we have another recourse with the jury nullification. There's a gentleman over here in the blue shirt on their phone. Did you have your hand up?
Oh, yeah.
Yeah.
I did. You mentioned some foundational principles
Yes.
and nuances tonight that I've never heard before,
Good.
including the Pledge of Allegiance.
Mm-hmm.
And so I'm kind of really thinking I need to go back to school.
We all do, for sure.
So are there, besides your own website, are there other really good resources where we can learn about some of these things in depth?
So there's three. So shameless self-promotion, 3 Liberty Society. We have a 6-class boot camp on liberty, and then there is a YouTube channel called Teacher of Liberty it's Dr. Joe Wolverton, and he has classes and videos that go over principles like these.
What was the last name?
Wolverton, Wolverton. He has a fantastic book called The Founder's Recipe as well. And then the John Birch Society has a brand new video series called The Blueprint for Liberty that gets into these principles as well. Yes?
So, what would be, in your opinion, the pros and cons of different states choosing to secede from the Union?
Pros and cons. So, I mean, of course, when somebody were to say, you guys have violated the contract too much, I'm out of here, some of the downfalls of that where you don't have the protection against foreign invasion, that kind of, you don't have as much protection in that. And, to be able to get the military might to defend yourself would be very expensive to do so that would be a downfall. Some of the pros would be, you're able to follow the law. And so, you're able to maintain your liberty. And so, you have to look at the cost-benefit analysis and see, do we want to stay here and enforce it, or are we just like, hey, you guys aren't going to do anything, let's just get out of here. So, there's lots of different.
Were you aware that Morgan Philpott did sue the state of Utah?
Yes.
Okay. Yeah.
Yeah.
I guess just one more comment, thinking about the scripture that says where two or three are gathered in my name. And I think that as we think about any system, you've got a shadow side and a light side. And when 2 or 3 are gathered that can speak to the truth, they can still be in the system. But as long as I think the awareness that you showed us tonight, it allows us to see things with more open eyes and be part of the 2 or 3 gathered in his name. That can be a voice of light and truth. So thank you. I don't know if it means that we necessarily have to get rid of, we're still living in a system, but
Sure.
how we, and break away or whatever, but there's a way to now, with new eyes, with even just 2 or 3 of us gathered together to bring a little bit more light.
As James Madison said, if we can get them to get into line, that would be the best scenario for sure. Absolutely. Yeah.
It's from my experience, more than a few months, it's been a while.
Yeah.
Is that one of the biggest challenges is, because oftentimes people get caught up into their own cause, whatever it may
Yeah.
be, and they'll say, well, write your congressman, okay? The reality is that the people in the legislative body are clueless as to what fundamental law is. Absolutely clueless. And I don't care if they're attorneys, which even makes it worse because they were never taught in proper law, fundamental law to begin with. And so the biggest challenge, you could write to them, et cetera, and I've had discussions with legislators, and I know you have too, and I said, so what's the skinny? How does this work? And they says, we never read the bills. We never read them. They said, we just rely on the speaker or the president of the Senate to tell us what to do. And so, you know, it's like, and in each constitution, the people have the right of assembly, they have the right of recurrence of instructing our servants, that's our right and our duty to do, and the redress of grievance. And in 2020, the Utah legislators were actually trying to remove that so that they had the authority to see if the remedy was acceptable to them or not. And it got bumped out at the last minute by the state Supreme Court. But they even said, we're going to keep going with this. We're going to push until we get it through. And so they've revamped the whole Constitution unlawfully, unconstitutionally.
And that's not an accident, and that's not through ignorance. We are facing a conspiracy, and the sooner we realize that, the better off we'll be. I encourage you also, again, to become a member of the Tree of Liberty Society. We have a weekly live training online where we go into more details every single week. We have action programs, we have action plans, and in addition to getting into building our understanding. So thank you so much for being here tonight. Thank you so much for your time. And I'll turn it back over to you.